Good morning. This is Travis Copenaver.
I'm Nicholas Melendez.
We're the Cannabis Legal Group. We're here on April 5th to talk about topics in marijuana and medical marijuana. Today, in celebration of the 47th Hash Bash that's scheduled to occur this weekend on Saturday, we thought we'd take a little bit of time to talk about the proposed ballot initiative to legalize recreational marijuana in our state. Hope you're all having a wonderful Thursday morning. Let's get into it, Nick. What is the proposed ballot?
So as a lot of you are aware, this effort's been going on for a while in Michigan now. Last year, the same group or members of the same group were trying to get this on the ballot last year. Unfortunately, they thought they had enough signatures, but there was some legal issues with it, and they didn't satisfy the required amount under the law. But for this year, they got enough. I think it's 360,000 signatures. It hasn't been officially verified yet, but what they did basically was create a ballot initiative that'll be on November's ballot. Called the Michigan Regulation and Taxation of Marijuana Act, and it allows for adult use marijuana for adults 21 years of age or older.
Okay. Well, let's talk a little bit about like the basics of what the law does. So, should this law pass, and on 21, what's the new thing that we get to do in Michigan?
So basically, you can personally possess and use it.
Okay.
You're able to cultivate it and sell it, both marijuana and industrial hemp, which there are some restrictions on federally and from the state from doing. It's also going to tax the revenue from these marijuana establishments and create kind of a framework similar to the MMFLA, where the state will create administrative rules and an application process, and also there will be certain violations for civil penalties, civil infractions for violating the act rules.
Okay, well, let's talk about some of the basics. So someone who's 21, if this law is in effect, is able to possess up to 2.5 ounces of marijuana at any given time. But that's just in general. If you have more product in your home, you can have more than that, correct?
Yeah, so within your residence, you're allowed to possess and store no more than 10 ounces of it, so that's significantly more that you're allowed to have in the room. And then also it allows up to yourself personally to cultivate 12 plants. Okay,
so unlike the current medical system, should this law go into effect, anyone who chooses to do so, whether or not you have a medical condition, can cultivate plants on his or her behalf. And then, what happens if I'm really good at growing and I produce more than those 10 ounces? Isn't there a restriction on how much I can have at that point, or is there?
Well, in terms of, say, giving it away, there are definitely some things in there that allow you to do that. If you had any excess, there's those certain limits where you can, the 2.5 ounces and the 10 ounces of it. But if you actually wanted to give it away, you're allowed to do so as long as you don't advertise or promote that you're actually doing that, out to the public or posting it on Instagram or Facebook or any kind of public announcements.
So actually, you can have 2.5 ounces of marijuana. Anyone can. You can store up to 10 in your house. You can cultivate 12 plants, and if you choose to cultivate 12 plants, there's no limit on the amount of marijuana you can have if it's from plants you cultivated yourself. So that 10-ounce restriction is only for people who are not growing their own supply. If you're with friends, if you're with family, and you want to share some of your product, you can do that, whether you've grown it yourself or not. The only restrictions, as Nick mentioned, is you can't advertise that you're doing that. You can't receive payment for giving someone marijuana as an individual.
And also to add off of that, there's certain restrictions where you can have that 2.5 ounces out, but then if there's any excess, it needs to be kind of locked away in a storage, safe kind of locked area within your residence.
Okay. So yeah, that's basically how it works. Just if you're in Michigan and this law is in effect, you're no longer committing any crime for being in possession or consuming marijuana as an adult. So that's all well and good, but marijuana needs to come from somewhere. So just like in the Medical Marijuana Facilities Licensing Act system, this law is going to create a set of different types of commercial licenses. Let's get just briefly what those new licenses are going to be, and we can talk a little bit about how each of them work.
Mm-hmm. So there's the basics. There's going to be growers, both class A, B, and C, and we'll get into this later, but it'll be important to make those distinctions because the numbers are a little different. There'll be testing labs, the safety compliance facilities, secure transporters, what will be called retailers, which is, I guess on the medical side termed the provisioning centers, as well as a new category called micro businesses.
Okay. So more or less, with the exception of micro businesses, the other licenses are at least have an equivalent in the medical program.
Mm-hmm.
So let's start with a micro business. What's a micro business?
So a micro business allows you kind of to be a self-contained marijuana establishment where you can cultivate no more than 150 plants. You're allowed to process and package it, and you can sell to anyone else who is not a marijuana establishment. So basically any adult 21 years and up, you'll be allowed to sell your own strains of marijuana and marijuana-infused products and so on and so forth, but only from that store. So it's definitely going to kind of, it's the other hand of the monopolization. It'll allow more like craft brewing, but to the extent that craft breweries can sell to other places, as a marijuana micro business, it will be just at that location.
So more or less what a micro business is kind of like the next step for people who currently are caregivers in a medical system. You can grow your own plants, you can process your own plants, you can package and have products available for sale. You just can't provide any of those products to other licensed businesses in the recreational system. So, more or less, it's more of a small scale, one stop, small business. Now, I'm sure those products still need to be tested and things if you're going to be selling it to the general public. But it is an opportunity, and it is designed to provide an opportunity for small businesses and people who want to go from the old systems and make their splash into the new recreational system. So that's a micro business. But there are, all the other businesses are more or less to the equivalent of what a medical marijuana facilities licensing act business would be. Now, you mentioned grows are going to get confusing here. So if this law goes into effect, we still have a Class A, Class B, Class C grow under the recreational system. But, and this will be something we'll have to be careful with, the plant counts for recreational licenses are not the same as the plant counts for medical licenses. So just to remind everyone, under the MMFLA, Class A's are 500 plants, Class B's are 1,000 plants, Class C's are 1,500 plants. How do the ABC systems work in the recreational bill?
So under this initiative, the Class A grower is going to be 100 plants, Class B is 500, and then a Class C grower jumps all the way up to 2,000 plants.
Okay. So, we'll have to be very careful about how many plants you have and which license you're trying to go for. But it sounds like both a Class A, which is 100 plants, and a micro business are both licenses designed by this ballot to provide opportunities to smaller operations. So again, there's a lot of little distinctions and differences between the recreational system of licenses and the medical system. One I'd like to highlight is this. Under the MMFLA and the medical side of things, there's no limit on the total number of licenses you can own as an operator. But there are a few limits in the recreational bill. For example, we have the concept of stacking Class C licenses under the MMFLA, which means if your facility and property can fit them and the municipality you're operating in allows it, you can have as many Class C licenses and increase your plant count, really to no limit besides, whatever local law says you can do. That's not the case in the recreational system. For the first, I think it's 2 years, there's a deadline on when
2023 or 2023.
For the first several years of the program, no operator can have more than 5 growing licenses. So it's not going to allow, big established businesses to come in and commandeer the entire cultivation market of licensing. It's going to, basically create some competition, and you'll have a lot of small manufacturers of wholesalers of marijuana operating in the program.
And also along with that, it only allows an operator to have one micro business license as well. So it's kind of going to, be pretty interesting to see how that plays out if the ballot issue does pass.
Right. So the micro businesses are designed to provide an opportunity to smaller players, but you can't have a big, large, cannabis operation with several licenses all throughout the state and also claim to be a micro business. You either are a micro business or you're the other types of licenses. You're one or the other.
Now, the law too. Sorry for
please go ahead.
The law does allow LARA, and we'll get to that too, as far as the structure of the application process and certain things they're allowed to and not allowed to do. It does allow them to kind of eliminate those restrictions on the license types that can be owned if there's certain criteria to allow the more efficient delivery to rural areas, if there's a need for more demand of the product, as well as if they see a problem with the black market with this system going, they can kind of get rid of that restriction.
So there's some flexibility built in
Yeah.
for local government and the state.
Mhm.
All right. So more or less, those are the licenses. Just like in the medical system, if you're a secure transporter, you can't have ownership interest in other license types. If you're a safety compliance facility or a testing lab, you can't have ownership interest in other license types. And then specifically for recreation, if you're a micro business, you can't have ownership in other license types. So we see that on the medical side of things. If you want to be a grower, processor, and what we call a retailer under the recreational program, you can have multiple ownership stakes in several of those operations, with the recreational only allowing you to have up to 5 cultivation licenses or grower licenses. So those are the licenses in general. And then just like in the medical program, municipalities play an important role in where these businesses can be and how many. So what are some of the municipal decisions that will have to be made once this bill gets approved by voters?
Well, once it's approved, if and when it's approved, each municipality is going to have the power to allow or completely prohibit these types of recreational facilities within their jurisdiction. But the interesting thing about it is it also specifically allows the people of those municipalities to, by a ballot initiative, adopt an ordinance either prohibiting or allowing these facilities. So I think there's going to be no question. We here talked about in Detroit that there's the legal issue going on in there with the initiatives that happen there. There's going to be no question, at least under that the regulation law, that will be allowed by ordinance.
Okay. So, there are some similarities to the role municipalities are going to play. A municipality is effectively going to have to allow these businesses to exist. But unlike medical, where it's very, very clear that you cannot exist should the municipality just decide not to, there are additional options for operators and people wanting to participate in this industry to attempt to get their community to allow them to do so. We do see in marijuana in general, elected officials are sometimes slow to adopt to the general public's desires. So should a municipality either pass an ordinance that allows these facilities and the community doesn't like them, or not want to pass some sort of ordinance allowing these facilities and the general public or their constituents feel that that's not appropriate, there are ballot tools, local ballot tools for those communities to put that issue directly to the voters to decide what the appropriate rules should be. So it'll be an interesting scenario to see, once this law is in effect, how municipalities are going to respond to it, and if those municipalities are kind of out of touch with the general public in those communities, if those communities are going to go through the ballot process and try to get these businesses either up and running or potentially limit those businesses if the people don't want them.
And I think another additional thing that's interesting in this ballot initiative is that there's a term called unreasonably impracticable. And I know for a lot of you who have been watching and are interested in starting a business or have applied to a lot of municipalities, there are some that are more relaxed and some that are very strict on the types of hoops that they want you and requirements that they want you to satisfy in order to get permitted locally. What the ballot initiative would do is kind of restrain both the municipalities and the state from passing requirements that are unreasonably impracticable. And that kind of is based on, and let me read it because it's a little bit convoluted. It's the measures necessary to comply with these rules or ordinances that would subject a licensee to an unreasonable risk or require such a high investment of money, time, or any other resource or asset that a reasonably prudent business person would not operate the establishment. So what do you think that means?
Effectively what it means is, this law is designed to allow these facilities and allow people in Michigan to lawfully produce marijuana. There are some local zoning and limitation decisions municipalities get to make, but a municipality cannot create a system that is so burdensome that it creates significant barriers to entry. There is no general prohibition of marijuana in our state. You might be able to limit the number of businesses in your community. Like individuals are able to possess up to 2.5 ounces, grow up to 12 plants in their homes, have up to 10 ounces stored in their homes, even share and provide marijuana they might have with their friends, family, people they know. If these businesses are allowed to exist, the state is going to define what limitations are on those businesses. The municipality's role is really going to be more about limitation and zoning. Another interesting note to look to, so unlike the medical program where there is really no zoning mandated by the state save for the location of growing licenses. They need to be in industrial or agricultural type areas. There is a bit of default zoning suggestions, I'd call them, built into the ballot. And everyone should know this, municipalities specifically, there's no requirement that a medical marijuana facility be located, 1,000 feet away from a school. That is just incorrect. Most municipalities do have that restriction. I think it's a good restriction in most cases, but that is not a state requirement. In a community, if it makes sense for that to be different, they can say 500 feet away from the school, or 700 feet away from a school, or 3,000 feet away from the school. Under the recreational ballot, as proposed, it does suggest that marijuana facilities be located more than 1,000 feet away from a K through 12 school. So if there is no restriction like that in the ordinance, the state does, by default, require you to be outside of that buffered zone. However, a municipality can, should it choose to, change that distance restriction that way, because no city or township in Michigan is the same. They're all laid out differently. That restriction might make sense in most places, but not all of them. A community can decide when they're drafting these ordinances to allow businesses to, make an appropriate change to that restriction. Mm-hmm. But above and beyond that, just like under the medical marijuana list, MMFLA system, other zoning restrictions and buffers can be implemented by local municipalities.
Yeah, I mean, the ballot issue is going to allow them to regulate time, place, and manner, mm-hmm. and display and advertising, just like other ordinances across the board allow these local municipalities to have control of.
Just like municipalities regulate the same types of things for any business in any industry. It's going to try to take marijuana and treat it the same way other businesses and industries are treated. Obviously, with some restrictions in place, it is still marijuana, and we need to treat it as something that isn't the same as like a tomato. But we are moving into a more legitimate, open acceptance of marijuana, and these businesses and the restrictions on them are going to be reflected as such in the ballot. Municipalities still have an important role to play. There's no guarantee that just because you have a medical license, that community is going to allow recreation. It is going to be a separate type of license, and you're going to have to go through a separate licensing system. However, there are restrictions on, especially for the first several years of the program, how to qualify to get a recreational license. For I believe it's 2 months after the state starts, 2 years after the state starts accepting applications, there are 2 restrictions in place on what types of operators can qualify to seek a recreational license. What are those restrictions there?
Oh yeah, so for the basically there's a year after the effective date of the ballot initiative for Lara has to create rules similar to how they did with the MMFLA and start accepting applications a year after. Mm-hmm. But it says after, up until 2 years after that, for Class A growers and for micro businesses, you're only allowed to take applications from residents of Michigan. For all of the other licenses, except for testing facilities, those licensees will need to be licensees under the MMFLA. So there's kind of a tiered system that, those smaller businesses that Travis and I talked about, the 100 plants and 150 micro businesses are going to be solely, exclusively available to Michigan residents. And then you kind of go from Class B and C growers into other ones that are going to need to be licensed under the MMFLA.
So practically speaking, for the first 24 months after the state takes a year to put all the program together, in order to be any of the commercial license types, save Class A's and micro businesses and testing facilities, so that's your processors, your transporters, your retailers, your Class B's, your Class C's, you need to be license holder of an MMFLA license. If you're not currently in the process of trying to get a medical license and you only want to be a recreational license, you have to either wait for the first 24 months or be a resident of Michigan. That's going to do a few things. It's going to make sure that local Michigan people have an opportunity to participate in Michigan's new program, should this ballot be passed. And it's also going to show that anyone else who's going to be participating in this program has laid down some roots in Michigan and gone through the significant vetting process and approval process of the MMFLA.
And compliance. Compliance is going to be big.
Yeah. So, keep that in mind. And that's, an important thing to think about when you're deciding whether or not you want to pursue a medical license right now. It will open up the opportunity to take that next step into, the larger, more lucrative recreational program from a business's perspective. So, and then the final thing we should probably touch on is what the benefit to Michigan is. So, all these new commercial licensed businesses will start popping up, go up and running. There are some differences for how that's going to have an impact on the state's, revenue and taxing and things. So the first thing to keep in mind is there will be an excise tax on recreational marijuana sales, 10%, correct?
Yep.
So when you go into a medical marijuana, I'm sorry, I keep saying medical, it's built in. When you go into a marijuana retailer or the equivalent of a recreational dispensary, on the purchase of products, there will be a 10%, tax on those purchases. That 10% goes into a fund for the state of Michigan. It's going to do several things. Do you know a little bit about how that fund works?
Oh, not off the top of my head. I think we might have to wrap a little bit more around those numbers. But
all right, so
kind of similar to the MMFLA, where a certain amount of that fund is distributed.
Yep. So more or less, what happens is it goes into a fund in Lansing. First, it covers the administrative operating costs on the state for facilitating this program. So first, covers costs. Beyond that, and for the first 2 years of the program or until 2022, the first $20 million goes to a fund to specifically research the viability of marijuana in treating veterans of our armed forces and their medical conditions. Specifically, it's listed to prevent, they want to make sure some of that money is going to researching how marijuana can assist in preventing veteran suicide. So, number one, it covers operating costs. Number two, it is going towards $20 million of that fund is going specifically towards those research programs. And then the remainder is distributed to participating actors, municipal actors, just like it is in the MMFLA with some different numbers. So 15% goes to communities with, local municipalities that allow either marijuana retailers or marijuana microbusinesses. So unlike the MMFLA, where it's any license type, the prorated distribution is based on point of sale. It's the more microbusinesses you allow, the more marijuana retailers you allow, the bigger chunk of that 15% you get as a local municipality. 15% prorated the same way goes to participating counties, and then the remainder is distributed to two funds for the state. 35% of what's left goes specifically to K through 12 schools. The other remaining 35% goes to fixing Michigan roads and bridges, hopefully, fixing potholes and things like that. So a couple of things to keep in mind. If you're a municipality and you are going to want to, obtain some of the revenue of this new recreational program, you need to allow microbusinesses or marijuana retailers in your community. The more of those you have, the bigger cut of these distributions you're going to get, both as a county and as a local municipality. So, and then as consumers, the more you buy and support the sale of these products, the more money is going to go to schools, go to fixing our roads, go to these research programs for helping our veterans, deal with their, medical conditions and prevent suicides and things like that. So that's a big, broad strokes overview of what the law is trying to do. We can, talk about a few little things that we've seen in it, and then, kind of wrap things up from there. So, anything stand out to you about how this law works?
Oh yeah, I think the most important thing too, because we had talked about the application process and what kind of licenses there are. But the biggest question I think people still have, at least on the medical side, and we'll have going forward, is what about my criminal convictions? It'll be recreational now. How do those impact my ability to get a license? And
sure. So, just for a reminder, in the Medical Marijuana Facilities Licensing Act program, if you've had a felony in the last 10 years or a certain type of misdemeanor in the last 5, controlled substances misdemeanors, fraud, theft, dishonesty misdemeanors, the statute prohibits you from being an operator or have equity in an operator in the MMFLA system. Do we see that in this ballot? Do we see that type of restriction in place?
I think it's still a skeleton framework, and Laura will continue to create rules if and when this gets passed that will look similar like the MMFLA rules, but specifically in there it says that a prior conviction for a solely marijuana-related offense does not affect your eligibility whatsoever, except if it was related to distributing to a minor. So that significantly kind of changes the whole quotation here with how exactly, who's going to be disqualified, who's not. I know Barton is really all about social justice, and so are we here, and a lot of other states in their ballot initiatives for recreational adult use marijuana have put in, I know California has said, we're going to expunge all of these ones in the past. This one doesn't have that, but at least as far as, having that disqualifying conviction on there, that's not going to apply if it's solely for a marijuana-related offense, not to a minor.
Right, and that doesn't mean we as a state of Michigan can't pursue that again. But the ballot can only do so much. This one at least has some rules built into it, so the state of Michigan can't prohibit people who've been in the cannabis industry and might have ate a charge here or there in their past from participating. Only exception to that is if you were convicted of providing marijuana to minors, they can prohibit that, based on what the rules lay out.
Mm-hmm.
A couple other things, they do allow for industrial hemp in this ballot initiative. There isn't a lot of, tie-barred kind of rules and explanation of how that's going to be implemented. I think a lot of that's going to be left to the state in their administrative rule process to define how that's going to work. So there is a lot of room in this ballot for the state to come back and basically create a structure to implement it. And we saw that happen with the Medical Marijuana Facilities Licensing Act as well. We're currently operating under emergency rules there. There's going to be a period of time when they put the finalized rules together. We're likely to see something like that happen again with this ballot here as well. Mm-hmm. Something I'd like to mention is we should keep in mind, I personally think this is great. I think it would be wonderful for our state, but we should be realistic as well. If this does happen, and this ballot goes into effect, that doesn't mean it's permanent. The legislature of the state of Michigan can pass additional laws to perhaps change or limit or make some adjustments to how this law is going to be implemented. If it is passed by a ballot initiative, that would need to be done by a supermajority of our legislature. So 3/4 of the Senate and House need to pass those rules, just like they did in the MMFLA when they created some adjustments to it. But there are some things in here that are great from the advocacy industry's perspective. But if you're not 100% all in for cannabis, there are some concerning things here that I can see. There might be efforts to adjust or change, from a municipality's perspective, from the state police's perspective, maybe from the state's perspective. So we should be aware that getting this ballot passed would be wonderful for our industry, wonderful for the state of Michigan. But there is an opportunity for some adjustments and changes to be made. One of the big targets, I think, will probably be that ballot kind of process for local level constituents to try to supersede a decision made by their elected officials, by city councils or boards of trustees. But until it happens, first we need to see if the ballot passes. Then we need to see what the reaction to that's going to be. Regardless, should this ballot pass, recreational marijuana is going to be a reality in Michigan. It'll probably go through some growing pains as how to implement it, but we'll get through that. It's going to be something I'm sure our state can figure out.
And then just on a closing note to kind of jump back on my social justice soapbox,
Sure.
It does, part of this ballot initiative does allow or does force Laura and the state to kind of create a plan to allow those who've been disproportionately affected by criminalized marijuana laws to be allowed to be in this industry, and also a plan to positively affect their community. So I think another good aspect of that is those things in place to get the state to kind of get on board with that and create those opportunities and avenues for those groups and individuals affected to kind of break free from what was kind of putting them in that disproportional disadvantaged area for so long.
Sure. So Stephanie, you're asking what about a felony from 12 years ago? Well, the ballot initiative as written doesn't create any prohibitions on what does or doesn't qualify you. So nothing in the law says that would be a factor in determining whether or not you should get a license. I think we're going to have to wait and see what the application and rules laid out by the state, should this law get implemented, look like. But today there's nothing to indicate that would prohibit you per se from seeking one of these licenses in the program. Also, on the medical marijuana side of things, under the MMFLA, if your felony, or a felony, I'm not saying year specifically, but if a felony is 12 years old, that's outside of the 10-year restriction. So, in theory, if you have a felony that's 10 years and a day ago, you're no longer prohibited by the statute from, holding or being a part of someone with a license. Now, it could be a factor to decide one way or the other, so it goes into what's more like a balancing test to see what was that felony for, what is your role in the greater company that's going to be holding this license, are there other factors that are concerning to the state as well? And, if all of that adds up to a yes or a no, it plays a role, but nothing in the statute prohibits you from having a medical license. I can't expect the recreational license restrictions to be any more restrictive than the MMFLA. So it shouldn't be a factor either way. But just like we've talked about in previous videos, disclosure is very important to the state of Michigan. So if someone has a felony from several years ago and you fail to disclose that to the state of Michigan, the felony itself wouldn't be disqualifying you, but your inability to inform the state that that occurred in your past might become a factor. Just like we saw some criminal elements affect some of the people who were reviewed by the board a couple weeks ago.
Mm-hmm.
So.
Yeah, and just in terms of all of those convictions and all of those criminal histories and other criteria that the board is going to be looking at, I mean, even for medical now and then whatever kind of review board gets set up in the future, if this does pass, it's going to be kind of time will tell. The board's only had one meeting on 2 licenses for medical now. What we're going to see in the future, how they react to certain different intricacies in each application, and I'd assume that's going to be the same for recreational if it does kind of get on board and get passed in November.
So like we said at the top of the video, this weekend is Hash Bash, high noon on Saturday in the Diag at the University of Michigan in the city of Ann Arbor. Nick and I will both be wandering around, so if you see us out there, please feel free to stop by, wave us down, say hi to us. It looks like the weather should be pretty nice this weekend, last I checked. So that should be great. We're also talking about the recreational ballot today because all the attorneys from our firm are going to be in Colorado next week for a fundraiser to support the Coalition to Regulate Marijuana Like Alcohol. So, if you want to support us, there's information about that on our website, cannabis-legal-group.com. The more we can donate to and support the Coalition's movement to make this ballot a reality, the better. They will be facing some opposition as we move closer and closer to the November election. There's plenty of wonderful information up on the website. You can read the initiative yourself. And on our page here, after we conclude the video, if you have more questions, we always try to stay on top of those and answer those even throughout the day if you think of things, if you didn't catch us live. Before that, are there any type of bank loans about with the MMFLA? That's going to depend. It's not impossible to get a loan to facilitate your project. It's just depending on what you're trying to get a loan for and if the bank's going to feel comfortable or not loaning to a business it knows is participating in cannabis. It's not impossible. Some banks are willing to do that. It's just a matter of what you're seeking, how much, what it's for, how much risk that's going to be on the bank. So it's hard to be more specific about that than without knowing more context. But yes, it is possible to obtain a loan from the bank. You can always get loans for other things as well. You can get a private loan from investors or people. You can always potentially if you have other assets, you can potentially get like equity or borrow against. You can free up some capital or create some liquidity to fund your businesses in that way as well. So there are certain options out there, obviously, because federal law and cannabis being challenging. Sometimes there are some loopholes and some speed bumps you have to overcome, but it is not impossible. So, yeah, we have another question about mortgages. We did a whole video, Craig and I did, on the challenges of getting title insurance for a real estate, deal that involves cannabis. Mortgages are the same way. A bank, just like a bank is usually hesitant to hold an account for marijuana industry, they're probably going to be hesitant to provide a mortgage to funding real estate acquisition as well. It's not impossible. Some banks are certainly able to do it. There's protections built into the MMFLA for financial institutions to work with cannabis clients, but that doesn't mean they're jumping at the bit to do so. So, it is what it is.
If anyone has enough money to buy a bank or start a bank or wants to take that risk, I think that's something that's really a good test case. But I think there's a lot involved with that. So
yeah. So all of our videos are on our Facebook page. You can also find them on YouTube at Cannabis Legal Group. Please like, subscribe. Visit our website. We continue to update our map for the participating municipalities under the MMFLA. Pleasure to talk to you guys today. We'll be back next week from Colorado with another show for you. We'll see you next time.